Joe-Santos Balagtas Bisquera, coming to you live in order to share with you my suggested answers to the labor law questions in the November 2022 bar examination. It's just a few hours away from Christmas. This is now the afternoon of the 22nd of November, of December rather, and we would be definitely celebrating Christmas in a little while. Now, suffice it to say that this is my way of trying to share my suggested answers after doing some research on the possible answers to the questions on labor law. I forwarded so far three sets of suggested answers to Bar Chairman Justice Benjamin Kagiwa, and we therefore feel that she may be able to pass on this particular thing to his own examiners for whatever it be its value. Labor law is very sentimental to me because this pulled down my grade in the bar examination simply because I was expecting the toughest questions in labor relations and termination of employment. And the examiner, when I took the bar, was kind enough to ask the basic questions on labor standards, and I did not essentially focus on that. So, to be candid about it, my lowest grade in the bar examination is labor law. Having said that, I'd like to confess that I made a couple of attorney's fees in labor law. And the biggest of which is I was able to help some of our own friends and associates at Motorola get their third month during the time that they were retired. And we won that particular case, a substantial precedence from a legal standpoint that even if you become liberal in giving away your separation pay of 2 months, but if there is already a vested uh, benefit that was given to the employees earlier, then the payment of a liberal retrenchment pay does not offset whatever is the vested right of the employees on benefits that they have already earned much earlier. So at the end of this particular sharing, which will not be very long, those of you who would like to listen for me to greet some of my own associates for 13 years in Motorola, I will make mention of them just to make this particular YouTube upload a souvenir for trying to remember since the last time we met, because we retrenched our employees sometime in 1998, and it is now year 2022. So you can just imagine that's about 12, let's say about 14 years ago that I have not met several of these people. And I just like to mention them as a means of remembering that we were once upon a time in Motorola. So to continue the ball rolling now, here is the little what we call this map that would show what were the modules that were given in the 2022 bar examination. Five areas were covered by about 12 questions. That's about 7, 8, 9, and then plus 3. That's 12. Yes, 12 questions given by Justice Kagiwa in the 2022 bar examination on labor. Termination questions had 4 questions. Labor standards covered 3. There was a problem on social welfare that got me to research on seafarers. I was not very sure. I have not handled any case on this, and so I had to look at that. There were 3 questions on labor relations, and one question on management prerogative. And you will see that this can become a very interesting question because this involved the issue of post-employment reservation for an employee who may not be available to be employed in industries that have been restricted. So we now proceed with termination and we will have the 4 questions under this. As usual, the question will be flashed and then I will click my suggested answer. You will notice every now and then there is a little circle that appears here that indicates a name that represents those subject matters or those questions that I anticipated and gave as my tip for my bar candidates. On termination, problem number 12 asks the question on discuss and differentiate between the procedural requirements in termination of employment for just and authorized causes. Explain briefly. There are 2 causes of termination grouped into the just causes and the authorized causes. Now, for just causes, the first one is serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. The second just cause is gross and habitual neglect by the employee of his duties. Let me emphasize the word gross and habitual. They have to concur in order for the employer to say, I do not like you anymore, you are neglectful of your duty. The third just cause is fraud or willful breach of the employee of the trust reposed in him by his employer or duly authorized representative. There are organizations, and Motorola Philippines was one of them, where dishonesty immediately calls for summary dismissal. And one of the major sources of this fraud is that we use gold wire in assembling our integrated circuits. And these gold wires can be pilfered because they're so tiny that you can actually just pocket it. In fact, literally, you can put it in your mouth on your way out of the factory. Next would be number 4, commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives. To me, the word duly authorized representative would essentially mean that if an employee should commit a crime like physical injuries or slander against a senior officer of the organization, that may fall under the concept of commission of a crime against a duly authorized representative. As to what level that would be, of course, the lowest level is a direct supervisor. That would really depend upon how the organization would look at filing a case of termination on the employee. And the last just cause is other analogous cases. And if you notice, this particular question on causes of termination was tip number 2 in my shortlist under page 4. Continuing now, in the area of just causes, what are the procedural requirements? And what is coming out here is the very famous employer's 2-notice rule on procedural due process of law. The first one that is required under the 2-notice rule is if there is a substantial just cause. Then what the company would do would be to serve its first written notice, serve on the employee, specifying the ground or grounds for termination, giving the employee the opportunity to explain his side. The employee, of course, under due process is expected to respond, and the employee explains the reason that he should not be terminated. And on the basis of these 2 sides now are on the table, management now decides whether or not to let go of the employee, and if the decision is to terminate the employee for a just cause, then a second written notice is to terminate. This is a very interesting concept because I did handle a particular case and it became a very interesting one. I am not very comfortable that we did not win that case at the level of the Supreme Court when we won it before the arbiter and also before the Court of Appeals. The very funny situation here is that the employee, a managerial employee, actually a vice president, was given the first notice where he had about 5 projects upon which the management called his attention that he was grossly neglectful. The employee, of course, was doing a lot of jobs, but he was able to come up within the 15-day grace period, I think even 10 days. He was able to explain that the 5 projects, 3 of them have already been delivered, and 2 of them have been deferred by management because of shortage of funds. And so management could not actually prove the issue of neglect. And so on the second notice, he was given the notice of termination on the second notice, not on the basis of neglect, but suddenly what came up is, of course, the second notice says loss of trust and confidence. We argued that before the labor arbiter, and the labor arbiter took our side and therefore ruled for illegal dismissal. We were reversed at the NLRC, but when we brought this up to the Court of Appeals, the Court of Appeals simply reiterated the position of the labor arbiter. What is really very obvious here is that the first notice talking about gross and habitual neglect was not proven by management. In fact, it was the employee who proved that he was actually a good employee. He was delivering. Now, but because management could not establish neglect, it issued the second written notice on the basis of a different reason altogether. And so you can see there is now that breach of a due process of law. Because the second notice, which is supposed to be to terminate him, mentions loss of trust and confidence, which is more or less in the area of fraud or dishonesty. It has nothing to do with the first one. And we won this issue before the labor arbiter and also the Court of Appeals. I am still awaiting some opportunity to resurrect this particular case before the Supreme Court and highlight that the Supreme Court first violated its own rule by way of getting the Supreme Court to meddle in a case which was already decided with finality by the Court of Appeals, affirming the decision of the labor arbiter. Jurisprudence points out that when the Court of Appeals adheres and supports the labor arbiter's decision, findings of facts and decision, the case will become final and executory. And so when the when the employer brought before the Supreme Court on a question of on a petition for review, there was nothing new that was presented. It is the same argument that was presented before the before the Court of Appeals. I am tempted to raise the issue again because I understand that there was so much interest among some segments that I will not anymore mention that essentially prevented us from questioning. In fact, I did question the Supreme Court and I was denied. But unfortunately, my client was so eager to probably do some other behind-the-scene maneuver that when his supposed benefactor outside of me filed the second motion for reconsideration, it was again denied And so that was difficult for me to go into a third motion for reconsideration until I raised an issue that the Supreme Court itself violated its own rule. And so I just wanted to highlight that in the two notice rule, the issue on the cause of termination given in the first written notice should be the same issue that should be the cause of the second and final termination. Moving now to the other slide. The second cause of termination would be the authorized causes. The first one is just causes. This one are authorized causes, and let's take a look at the first one. The installation of labor-saving devices would allow termination. The second one is retrenchment to prevent losses. The third one is redundancy, meaning there are two or more jobs that are overlapping, and therefore for purposes of efficiency and economies, cost economies, then certain positions can be declared redundant. And finally, the closing or cessation of operation of the establishment or undertaking. Again, these were all part of my tip number 2 on page 4 of my little handout to my bar reviewees. Now, insofar as the procedural requirement of these 4 authorized causes are concerned, let's take a look at them. In the case of installation of labor-saving devices, there is a need for a 30-day notice to the Department of Labor and Employment. In the case of retrenchment to prevent losses and redundancy, it is a 30-day notice to the employee. And normally, you would also have a copy to the Department of Labor and Employment. That the critical procedure here is 30-day notice to the employee. And finally, when you have a closing or cessation of operation of the establishment, you need to pay separation pay to the employee. Otherwise, you will be violating the procedural requirement on termination of employment. So this is problem number 12 and the first one that I'd like to share with you. The second question on termination is problem number 8 in the bar exam. And it has something to do with the security of tenure and the category of being a regular employee. The bar question runs like this. Julian was hired by Index Agency, a licensed manpower and recruitment corporation, which had a service agreement with Kainan Resto, a fast food restaurant for the provision of ancillary and support services. Index Agency assigned Julian to work at Kainan Resto as a cashier and counter clerk, whose duties involved taking customer orders, receiving payments, preparing food orders, and serving food to the customers. I was the one who highlighted that in yellow just to emphasize the point for you. Julian was accused of shortchanging a customer during one transaction. He was immediately dismissed from service by the manager of Kainan Resto. Julian filed a complaint for illegal dismissal against Intex Agency and Kainan Resto. In its defense, Kainan Resto argued that Julian was not its employee but that of Index Agency, given that Index Agency is a licensed manpower and recruitment corporation. Is Kainan Resto correct? Explain your answer. Our suggested answer. No, Kainan Resto is not correct. Julian is a regular employee whose work, taking customer orders, receiving payments, preparing food orders, and serving food to customers, is directly related to the Kainan restaurant business. Kainan is the principal employer and Index Agency is only involved in labor-only contracting. Julian cannot be dismissed without observing the substantive and procedural due process for just cause of termination, the thing that we just discussed earlier. And so, because of the nature of his work, which is essentially that of a regular employee, Julian cannot be terminated summarily by kainan resto, without observing substantive and procedural due process. Okay. Next question. The next bar question is problem number 9, and it had to do with a very interesting subject matter, the work pool employees. And this will remind us of the very classic noise that we heard from ABS-CBN crew. Going now to the bar question. Sigaw Corporation, a media entity, produces television shows. To streamline its processes, it created a database of camera crew and sound engineers whom it usually engages for its television shows. Sigaw Corporation pays them only talent fees each time they are engaged for a show. After several years of this setup, the camera crew and sound engineers filed a complaint for regularization against Sigaw Corporation before the labor arbiter. On the other hand, Sigaw Corporation claims that they are not regular employees but independent contractors or talents because they are engaged and paid for their specific technical skills. Rule on the complaint. Explain briefly. Our suggested answer. The complaint for regularization needs to be granted. Sigaw Corporation's business or trade is television shows. Camera crew and sound engineers are project employees who are vital, necessary, and indispensable to Sigaw's usual television shows. With several years' service, they are regular employees, regularly needed in Sigaw's business. And this was decided in the case of Ruben Carpio versus Mod Air Manila, a June 21, 2021 case, and earlier in the case of ABS-CBN versus Concepcion in October 2020. Again, this was one of my tips, problem item number 5 on page 5 of my tips to my candidates. And the last problem in termination is preventive suspension. This was problem number 10 in the bar exams. As human resources manager of a 5-star hotel, you were told in confidence by several fearful employees in the housekeeping department that Joy, the head of housekeeping, was a harsh disciplinarian who would pinch the ears of her staff or wrap their heads to drill instructions on the proper way to clean and tidy up the hotel rooms. One day, the assistant housekeeper urgently called you to the supply room of the hotel, where you found housekeeping staff Erica and Patricia slumped on the floor with bloody faces. The assistant housekeeper reported that she saw Joy beat up Erica and Patricia with a mop for allegedly stealing complimentary toiletries for guests. Erica and Patricia were hospitalized for a couple of days due to the injuries they sustained. Question A. Can Joy be placed on preventive suspension pending administrative investigation? If so, for what maximum period? Explain briefly. In letter B, if Joy is placed on preventive suspension, is she entitled to receive her wages and other benefits during the period? Explain briefly. Very interesting. Skill on supervision. Nanununtok. and I had an experience with this. I hope he would smile if he looks at this YouTube play in Permaline. We had a very good-looking and very efficient manager in the production line. I will mention his name. No, anyway, this is not derogatory against him. His name is Louis, and his surname is Arcangel. Louis is a very good-looking guy. He looks like the younger version of Romeo Vasquez. And he's a very good team player. He would be very supportive. Except when I sat down with the union on the collective bargaining agreement, we were not talking of merits of the CBA. They wanted to kick out Louis because Louis had the tendency to really use his martial arts, and he would even bring his gun in the evening shift, the what we call it, the graveyard shift, from 10 to 6. And when he catches an employee sleeping, oh my God, the kind of drop kick that that particular employee would receive would put our personnel manager, si Joviel de los Santos, in very deep concern. And he would come to me and say, Boss, paano ba naman si Louie? Meron na namang sinuntok kagabi. Ayun, nasa ospital. And so when we agreed, the three of us were good teammates working under our president and general manager, who is a family member, si Michael Yang. I'm still looking for Michael where he has gone. But Michael Yang is another very smart fellow. And he got the three of us to work together, and we were a good team. No? So with him as our leader, the three of us can work together. So one time we asked Louis to have dinner with us. And then at the time that we were having a lot of fun, with the beer and so on. And Louis is a very nice person. Si Joviel brought up the matter. Sabi niya, Brad Louis, I have a problem, sabi niya yung sinuntok mo, talagang mainit na yung union. They really like to confront you. Di uminit si Louis. Sabi niya, subukan nila pag hindi inubos ko sila ito 45. Binunot yung 45. And he's a martial arts expert. Ako naman natatawa ako because, I believe in discipline and things like this. But I am in between the two sides. I don't believe that physical harm should be imposed. But discipline is really needed. And strong leaders in the production line are needed. Kasi galing ako sa pier area. Sa pier dyan, pag ikaw kabo ka, hindi po pwedeng wala kang criminal record na marunong kang pumatay. At pumatay ka na. Ganyan kinakatakutan dyan. So I am also used to a situation where the element of fear should be should be present among the people who work with you. No? Although dapat naman dahan-dahan. So when we asked Louis, sabi niya, ako mas bata sa inyong dalawa, sir, pero ganyan po natutunan ko, teenager pa ako, nagwo-work na ako, and I work with an employer who trained me that yung mga Filipino workers na yan, pag hindi mo tinakot at sinindak yan at hindi natakot sa'yo, wala yan, tamad yan, magnanakaw yan, hindi magtatrabaho. So sabi niya, Sir Joviel, pasensya na kayo, that is the only style I know. Sabi niya, and I think it works. Sabi niya, kapag alam nilang darating ako, takot sila, yung mga natutulog, nagigising, sabi niya. And I had a lot of difficulty, especially because the union was affiliated with the federation. Siyempre, yung mga senior members ng federation, binibiro ako. Sabi niya, hindi pa ako abogado nun. So, Mr. Bisquera pa ako. And sabi nila, Sir, alam mo, hindi labor relations itong pag-uusapan natin. Ano lang ito Sabi niya, yung simpleng style lang ng management Paano ba natin solving dyan, sir? Kasi yung mga local leaders namin, kaya namin pasunurin yan. Kung sabihin mo na ganito lang kaya nyo, kaya namin, sabi niya. Pero ang hindi namin kayanin, talagang hindi na raw nila kaya matiis at nagtatawag na sila ng suporta na alam niyo na, sabi niya na kailangan sigurong gumamit na rin kami ng muscle. Sabi ko naman, ayaan yung ako at kinakausap na namin. Style lang niya yung ako, pero hindi naman ako masamang tao. So, well, too bad. I left the company because I was being headhunted by another very beautiful offer, and I had to move. But I will never forget these beautiful teammates that I have. Our boss, Michael Yang, Dalasal, summa cum laude in chemical engineering, and also si Joe-Santos, who at that time I think already has a Bachelor of Laws. But I have not had a chance to ask him whether pareho na kaming attorney at law. And then si Louis Arcangel. And Louis, I was able to somehow reach out to him. I told him, pare, mas mahirap yung trabaho mo nasa production line ka, gwapo ka at magaling ka magaling ka namang engineer ka. Mag-switch ka nga sa marketing at baka mas click ka. The last one I heard is he did switch to marketing and he was very effective. You know, he was selling from a technical selling point of view, was making good. Yung wife niya kasi was a very senior professor at UST and became principal of my UST Education High School. So napansin ko pareho Arcangel. So when I asked Dr. Arcangel how is he related to Louis, sabi niya, he's my husband. Natuwa ako kasi isipin mo, bigatin pala yung wife, edukado at lahat. And understandable naman, gwapo naman si Louis, nakuha niya, matalino rin babae. Pero I could not tell her, ma'am, bakit yung asawa mo napakabait tingnan at gwapo pero grabe kung mag-handle ng tao. Anyway, ito ngayon yung tanong natin. Meron etong si Joy, nasa 5-star hotel. Pag nakakita ng mga nandudukot, pasensya na kayo, medyo humaba ng konti, but this is also my opportunity to share with you real life experiences involving some of these questions. So our suggested answer is, dapat ba bigyan ng preventive suspension si Joy? Our suggested answer, yes, Joy can be placed in preventive suspension pending administrative investigation. Her suspension is to ensure that her use of physical violence in the workplace may prevent harm or injury to the company and to her fellow employees. Kasi pwedeng lumaban na rin yung mga empleyado, parang yung nangyari nga kay Louie na they are already threatening to also take massive action against him physically. Joy may be the subject of retaliation from those who may abhor her disciplinarian approach to preemptively harm her. Her suspension will not exceed 30 days when investigation may be conducted to establish the facts of violence in supervision. On question B, yes, Joy will receive her wages and other benefits during the suspension. Her violent supervisory style is motivated by her concern for the company, and it was not really intended to harm the company but to give the company the benefit. Style lang ng pagsusupervise, and probably she needs a little more training. And so to punish her by not paying her would be not doing justice naman to somebody who is trying to do her best in the best way she can. Kulang lang siguro ng orientation and training. So that essentially covers the 4 bar problems in the November 2022 that had something to do with termination. We are now ready to go to the second module where we now handle labor standards. Ito yung nadapa ako nung kumuha ko ng bar na nagtanong ng basic question hindi ko napasadahan ng gusto last minute. So let's take a look at labor standards. 3 questions. The first one had something to do with employee relationship and the right of control. And this is very interesting because there is another question not in labor law but in commercial law. It's something to do with the issue of common carriers. Tinanong, ewan ko, nauna labor law kaysa commercial law, but hiwalay naman kasi yung mga examiners niyan. Hindi siguro nagkatama ng gusto yung coordination. And so there seems to be an overlap. And it is very important, like in my case, when I'm providing the answer to commercial law, naka-upload na sa YouTube, panoorin nyo, tapos eto na naman, i-upload sa labor law. No? Dapat magtama yung dalawang yun. The problem, for example, in the field of legal education is merong mga nagtuturo ng ganitong subject na what he may be teaching may be contradictory naman to another field, no? Katulad dito, labor law versus commercial law. That's why very important may integration. Hindi naman lahat tayo mga abogado ang parating ang tanong, Dean, ano ba specialty mo? Hindi dapat specialty kasi pag pumalak sa bar, pasado ka sa lahat ng subject. You are not like a doctor na may specialization sa cardiology o sa kidney. Hindi tayo ganun. Tayo were expected to handle cases, although because of experience, medyo naging mas magaling tayo doon sa ibang field. So now, let's take a look at this one. Ito yung similar setup sa Grab. Ang pangalan lang ng Grab dito, ginawang Kotse Corporation. So, going over the problem now. Kotse Corporation operates a mobile phone application, Kotse PH, that allows users to book private cars on demand for their destination and matches them with nearby available driver partners. The destination is only made known to the driver partners when the users have boarded the vehicle. Kotse Corporation has an accreditation process for its driver partners who are required to submit biodata, professional driver's license, and negative drug test results, as well as pass an exam on road safety. After accreditation, the driver partners are free to choose their own work hours, but Kotse Corporation requires them to complete at least a total of 40 hours per week, or else the driver's share in the fare will be reduced. The fare is determined by the application software depending on distance, time, and the demand for rides. The fare is paid by the user or passenger through the application, and Kotse Corporation remits the driver's share of 75% of the fare every 2 weeks. Kotse Corporation keeps 25% as its commission. The driver partners are evaluated by the users or passengers through a 5-star rating system. Driver partners who consistently have an average rating of 2 stars or below may be removed from Kotse Corporation's roster of driver partners. The driver partners use their own vehicles, pay for fuel, and secure their own vehicle insurance. Question: is there an employer-employee relationship between Kotse Corporation and its driver partners? Let me give a very candid, sharing here. There was one, I don't know kung sa labor, but there was somebody who shared an opinion on this question, saying that because there is an element of control by Kotse Corporation on the drivers, then the right of control test would now allow us to conclude that there is an employer-employee relationship between Kotse Corporation or Grab and its drivers. With utmost respect, I disagree with that particular position. I do not subscribe to the concept that just because all of these qualifications are being asked, that this essentially is the control test that is required for employer-employee relationship. I guess that even suppliers, no, other than the service, can be subjected to evaluation and ranking. But it does not make the supplier any better than being a supplier and never an employee. My suggested answer therefore is there any employer-employee relationship? My answer is no. There is no employer-employee relations between Kotse Corporation as the Transport Network Company, TNC, that is Grab, and the independent driver under the Transport Network Vehicle Service. So there is no employer-employee relationship. The independent driver is the common carrier engaged in the business of carrying the passenger for a fee. The driver's use of Kotse's mobile phone network, for which he pays a fee, the 25%, does not place them under the control and supervision of kotse under the Supreme Court's right of control test. Up here, I now continue by saying the driver observes the extraordinary diligence imposed on common carriers. The same diligence is not required by law of Kotse Corporation. No, you do not sue Grab just because the driver was reckless. Kotse is not involved in the means or methods of the driver in bringing his passenger to the destination. Sarili niyang diskarte. So that is the first problem on what you call this on labor standards. No, Grab is not the employer of the driver contractors. Going now to the second question on labor standards, conditions of employment, and very popular question on overtime. Chris is a daily paid factory worker who is required to render 8 hours of work per day. 2 days ago, he rendered only 7 hours of work as he arrived late in the morning. Yesterday, Chris worked for 9 hours as he was required to assist in the processing of perishable goods. His supervisor, Rudy, told Chris that he would not get any overtime pay as his work for 9 hours yesterday was meant to offset the 1 hour shortfall in his work the day before. Question A. Is Rudy correct? Explain briefly. And second, B. Assuming Chris is entitled to overtime pay, how much will he get as overtime pay if his daily wage is 640 pesos? Explain briefly. Our suggested answer. A. No. Supervisor Rudy is not correct. Overtime work should be paid. Prior undertime cannot be an offset against actual overtime work. Rudy should pay Chris the overtime work on the extended hours. Let the undertime hours be deducted from his available leave credits. Now, as a side comment, and this may or may not be included in the answer, because the answer here is already complete. Work may be performed beyond 8 hours a day, provided that the employee is paid for the overtime work, an additional compensation equivalent to his regular wage plus at least 25% thereof. Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus at least 30% thereof. Okay. Now, question letter B. The question is, how do you pay now Chris if he is earning 640 pesos? Now, here is our suggested answer. Worker Chris will receive his base pay of 640 for 1 day. And that is, of course, 8 hours at 640 for 640. But we show this because we want to show the overtime. The overtime is 1 hour. And therefore, that will be equivalent to 100 pesos computed this way. He worked for 1 hour, and that 1 hour is supposed to be the 640 per day divided by 8 hours. That will give you the amount of the extra 1 hour overtime using the base rate. But the base rate now, you multiply by 120%, and that is how you finally got the 100 pesos. So, the total pay of Chris during that day that he worked overtime for 1 hour is 640 for the first 8 hours and 100 pesos for the extra overtime hours that he worked for. Okay. This is based on Section 87, Chapter 1, Title 1 of Book 3 of the Conditions of Employment under the Labor Code. And this was tested, by the way, my dear friends, in the Nawasa versus Nawasa Consolidated Union in August of 1964. Now, The third question on labor standards, sexual harassment. This one is very, very tricky. And I again overheard somebody whose answer is not the same as my position. And so let us read the problem. Due to Bitoy's repeated unwanted sexual advances towards his co-worker Diego. Take note ha, si Bitoy supposedly lalaki. Yung co-worker lalaki din. Diego went to the personnel manager to report Bitoy's behavior. The personnel manager started a disciplinary action case against Bitoy. In his written explanation, Bitoy denied the allegation of sexual advances. Siguro si Bitoy medyo may pagkabading, parang himas, no? He also pointed out that sexual harassment only pertains to a superior-subordinate relationship, where the perpetrator is the superior and the victim is the subordinate. Yan sabi ni Bitoy. Hindi pwedeng may sexual harassment kasi ka-level lang naman kami. Hindi naman niya ako boss. And so, since Diego is not his subordinate, as they are co-workers with the same rank, Bitoy cannot be subject to disciplinary action. Yun ang sabi ni Bitoy. Is Bitoy's contention correct? Now, this requires little knowledge of sexual harassment. Our suggested answer. Bitoy's contention is correct in line with the Anti-Sexual Harassment Act. The harassment consists of sexual advance done in the abuse of one's authority, influence, or moral ascendancy related to work, education, or training. The relationship of superior-subordinate is a component part of such abuse. And so Diego's discomfort may not amount to sexual harassment, but other acts of lasciviousness, seduction, and unjust vexation. So it doesn't mean walang cause of action si Diego labang kay Bitoy. No? Dahil medyo inaano siya, niroroma-romansa siya. No? Hindi papasok sa sexual harassment dahil hindi naman sila boss-subordinate relations. Pero dahil nabubuisit siya, siguro merong unjust vexation. Tinutokso siya, therefore may seduction. Or medyo hinihimas-himas na siya, meron acts of lasciviousness. So this is very tricky. Hindi lahat ng mga medyo undertones, overtone na sexual, sexual harassment. There has to be a subordinate superior relationship. Kung nagkakatuksuhan at magka-level, hindi sexual harassment yun. Acts of lasciviousness yun, seduction or adjustment. Pwede pa rin maghabla criminally, pero not under the sexual harassment concept in labor law. So, that essentially covers now the three labor standards problem plus the 4 we earlier said. So 7 out of 12. So 5 na lang. So now we move to social welfare. Ito very interesting. Very interesting. Tingnan natin, social welfare. The social welfare problem number 5 has something to do with the migrant worker and his disability. Let us now read. Marino, a seafarer, was engaged as an oiler on board Serena Corporation's oil tanker vessel. After 10 consecutive contracts, with each contract having a duration of 8 months and the last one ending on December 2021, Marino decided it was time to enjoy his hard-earned money and disembarked from the vessel upon the expiration of his employment contract. In April 2022, so December ito, so April, that is 4th month, he felt excruciating pain in his groin. He went to a doctor and was diagnosed with acute hernia. The doctor also determined that the hernia was caused by repeated heavy lifting because of his work as an oiler. As a result, Marino filed the case against Serena Corporation before the labor arbiter, claiming total and permanent disability under the POEA standard employment contract. Sierra Corporation raised in its position paper that Marino is barred from filing the case as he did not raise any complaints during the term of his employment and within 3 days from his arrival in the country after his last employment. If you were the labor arbiter, rule on Serena Corporation's defense. Explain briefly. Very interesting, no? Ang ano doon is hindi raw nagreklamo at the time he was employed or 3 days after he arrived. And citing, merong standard employment contract yan. Okay, let us now proceed with our suggested answer. Again, tinip natin ito. Problem number 19 on page 7. As the labor arbiter, I shall deny employer Serena's defense on Seafarer Marino's failure to make his complaint during the employment period mentioned. The seafarer's right for disability has been established because his acute hernia was medically determined from his repeated heavy lifting as an oiler. His substantive right to claim disability cannot be overtaken by his late claim, a mere procedural technicality. Kung naapi na po yung tao at meron talaga siyang damage, hindi naman po pwedeng gagamitan mo lang ng technicality parang palusot. So here, Marino deserves to be paid the total permanent yung compensation for total and permanent disability. That is the position I am taking. Now, we have already covered 8 problems out of 12. So, 4 na lang. 3 on labor relations. Let's take a look. On labor relations, problem number 3 refers to the legitimate labor organization when there is a union security clause. Okay. Ito, nangyayari ito, practical ito. May mga nagre-reklamong empleyado na ba't ako magbabayad ng union dues? Hindi naman ako union member. Okay. Christina, a new hire of Sterling Corporation, was made to join Sterling Corporation Employees Union in compliance with the union shop provision in the collective bargaining agreement between SCEU and Sterling. At the request of SCEU, Sterling started deducting union dues from Christina's salary and remitting the same to SCEU pursuant to the CBA provisions. Christina protested, claiming that she has not authorized the deduction in writing. Is Christina's claim valid? Explain briefly. Now, tingnan natin ang suggested answer. Our suggested answer is no. Christina's claim is not valid. The union shop provision of the collective bargaining agreement requires Christina to be a union member for her continued employment. Such required membership provides the labor union the authority to collect union dues for Christina as a union member. Christina can maintain her union membership as a condition for her continued employment only when she fulfills her duty to include the payment of the union dues. And this is based on an actual case in 2019 in the case of Slord Development Corporation versus Noya. Yan. So meron ang kasunod. Next, on labor relations, on self-organization and restriction of supervisors. This is basic. Hindi pwedeng maghalo yung union ng rank and file at yung union ng supervisors. Kasi iba yung iba yung perspective nila, iba yung point of view nila when they are in the workforce. Okay. So, problem number 6 in the bar exam. Sonic Build Corporation employed Leo and Dan. Actually, in the actual problem, ginamit na talaga si Leo and Dan in its cement factory and assigned them the tasks of, among others, directing and supervising rank and file employees. Leo and Dan are required to ensure that such employees obey company rules and regulations and recommend to the company's Human Resources Department any required disciplinary action against erring employees. There is only one union representing rank and file employees. May Leo and Dan join the union? Explain briefly. Our answer, no. Leo and Dan, being supervisors, cannot join the labor union consisting of rank and file employees. But they can form a labor union consisting of supervisors separate from the existing union. This is pursuant to Article 245 of the Labor Code and was tested in 2008 in the case of the Republic of the Philippines and Dole versus Kawashima Textile. No? There are some notes here on Article 245 that effectively is lifted from the case of Toyota Motor Corporation versus Toyota Labor Union in 1997, further amplified the Dunlop-Schlesinger versus the Secretary of Labor and Employment in December of 1998. Now, there cannot be any combination of rank and file and supervisor in the same labor union. The only question is, nung ipasok daw sa application ng recognition ng labor union, merong nakahalong supervisor, is the DOLE required to recognize the union? This was hotly contested. No? One school of thought is, pag may nakahalong supervisor, there cannot be any labor union that can be extended recognition. But later on, this was reversed in the Dunlop-Schlesinger case dahil sabi nila, pag sinubmit naman yung application, hindi naman nakalagay doon yung posisyon ng mga empleyado eh. So, sabi niya, the jurisprudence now says, no, according to Dunlop, recognize the Department of Labor and Employment should recognize the legitimacy of the union, but management now, when it goes to the collective bargaining agreement, can now question the inclusion of the supervisors in the supposed collective bargaining unit. So, pwedeng tanggalin. Pero tuloy, yung rank and file, dapat tanggalin yung supervisors. That is the latest in terms of recognition. Dati, hindi mare-recognize yung union pagka mistiso. Ngayon, hindi. I-recognize yun, pero pag nag-CBA na, paalisin na ngayon yung supervisor by way of negotiation. No? Mas matitinik yung mga supervisor. Tapos kabisado nila. That's why they can influence and strengthen the union. So management will also be interested na ayaw namin kasali kayo dyan. No? Tayo kayo ng sarili yung union and we will deal with you from that perspective. Continuing now. The third question on labor relations is this bargaining representative. Ito medyo I had to do some little research on the difference between certification election and consent election. As you know, when you have a group of employees, initially they're what are called unorganized, unregistered. Dahil wala silang union. No? Now, later on, because of the policy on collective bargaining, they will be encouraged to form a union and negotiate on a collective bargaining with their employer on their salaries and also their benefits. No? Now, in order to determine sino ito magiging representative to deal with management, nagkakaroon ngayon ng official representative which is derived by votation. Magbobotohan sila kung sino yung mga officers nila and ultimately kung may dalawang unions, kung sino yung union na mananalo pa to represent them. No? Yun ang tinatawag natin na pagka nagbotohan kung sino yung labor union na magre-represent, certification election. Pero, pwedeng magkasundo yung dalawang union na huwag na natin isali ang Department of Labor. Tayo na kasi marami pa silang mga seremonya. Tayo na lang ang magkasundo na pagbotohan tayo, simpleng botohan. Tapos kung sino manalo, yun na. Yun na tinatawag naman na instead of certification election, to choose the representative, magkakaroon ng consent election. Ito na ngayon ang tanong. Problem number 7 in the bar says, two legitimate labor unions, Union Jack and Union Jill, are competing to become the first sole and exclusive bargaining agent in Maharlika Company. The unions agree to a consent election, ayun, without involving the Bureau of Labor Relations. Union Jack garners an overwhelming majority of the valid votes cast during the consent election. Negotiation for a collective bargaining agreement commences, and while this is ongoing, a third union, Union Jambol, files with the Bureau of Labor Relations a petition for certification election. Meron ng third union ngayon. Sabi, hindi, mag-combine tayo at magbotahan tayo formally. Hindi kayong dalawa na nag-uusap kung sino representative sa inyo. Seeking certification as the SEBA in Maharlika Company. Union Jack opposes the petition, arguing that no petition for certification election can be filed within 1 year from the consent election and during the CBA negotiation. Is Union Jack correct? Explain briefly. The legal answer is yes, Union Jack is correct because a consent election bars a certification election for 1 year where the labor unions voluntarily agreed to said consent election with or without the intervention of DOLE's Bureau of Labor Relations. The straight to DOLE promotes the free and responsible right to self-organization. Sige, kung gusto nyo magkasundo na lang under a consent election, okay na yan, no? Through a simplified mechanism for the determination of representative status. Kung ayaw nyo nang kung magkakasundo na kayo under a consent election, hindi na tayo gagawa ng formal certification election. And when you therefore come up with that consent election, 1 year, hindi pwedeng may mag-petition na mag-certification election. Okay. So those are the 3 problems under labor relations. And hold on for a while. That already leaves us to the last problem in the bar examination on labor law. Management prerogative. Isang problem lang ang binigay. And it's problem number 11. Number 12 yung yung causes of termination. Ito na ngayon number 11. Post-employment restrictions. This I found a little difficult to answer and I had to do some little research. So reading now, Troxy, mukhang hindi Troxy yun. Mukhang pangalan Trixie. Let me just verify, no? Whatever, is a scientist researcher in the academe, specializing in vaccine research, particularly messenger ribonucleic acid, mRNA technology. At the start of the pandemic in 2020, Trixie was hired by AZ Corporation to help formulate and produce a vaccine against COVID-19. The employment contract provides, quote, "You shall not work for whatsoever capacity, either as an employee, agent, or consultant with any person anywhere in the Philippines whose business is in direct and indirect competition with the company during the period of this contract and for a period of 10 years from date of resignation or separation from the company. Violation of this stipulation shall make you liable for liquidated damages in the amount of 5 million pesos. Trixie was able to successfully produce the vaccine and for which AC Corporation paid her 50 million pesos. Thereafter, Trixie resigned from AC Corporation and returned to her work in the academe. AC Corporation filed a complaint for damages in the amount of 5 million against Trixie for violation of the above stipulation in her contract. If you were the judge, rule on the validity of the stipulation. My suggested answer, as the judge, I shall rule that employer AC Corporation's employment restriction is not valid for being in restraint of trade. The employer does not face any danger of unfair competition from Trixie's present employment with the academe. AC Corporation has not established the reasonableness of the 10 years restriction on Trixie's employment. So that is the position I am taking, that the restriction for her not to be employed is not violated when she does not join a competing company because the academe, the university, is not competing with AC Corporation. Second, yung 10 years, dapat i-justify naman ng AC Corporation kung bakit ganun katagal. Baka in 2 years lang, magkaroon na ng bagong technology. Tapos yung tao naman in Restraint of Trade, 10 years hindi makakapagtrabaho in any other capacity. Pati ba naman yung magtuturo sa academy, ayaw siyang payagan. And so with this, ladies and gentlemen, that allows us therefore to end our discussion of the 12 problems in labor law during the bar examination. And so I'd like to share my appreciation for allowing me to discuss with you the labor problems. I felt that the questions on labor, about 60-70% of the problems were supposed to be known by the candidate and should therefore get a correct answer. But there were some difficult problems. Kahit for example, yung question ng migrant worker na hindi siya nagreklamo kagad, doon substantive right yun versus procedural technicality magiging reasoning. No? And then the second one, itong post-employment restriction. Medyo bago ito and therefore pakiramdaman na lang ng principle of law. Okay? So with this, I'd like to thank you very much and wind up my presentation of my suggested answers. The second portion, which should not be very long, is for me to recognize my associates with the company that I have worked for about 13 years, from 1987 to 1994, if I remember right. 98. From 1987 to 1998 or something along that line. For a number of years, I was working with Motorola in the finance organization and ultimately became its finance manager. I was also head of the planning group and I had with me a lot of friends. 13 years is my longest stay with a company other than University of Manila, where this is now my 27th year as a member of the law faculty, as the dean for 2 occasions, and also part of management being vice president for legal affairs. But in Motorola, full-time yan. Araw-araw from Monday to half day Saturday, I would be reporting. And Motorola is a semiconductor company. It was initially way ahead in the area of cell phone, unang folding cell phone. But it also was very strong in the area of the raw materials for all of this electronics, which is yung IC, yung semiconductor, integrated circuits. We had our factory here in kilometer 17 here in sabi nga South Super Highway. Kilalang-kilala yung lugar namin kasi pag umulan, doon mismo sa loob ng expressway, bahang-baha sa tapat namin. Kaya parati sinasabi, doon sa Motorola, baha. Motorola is very sentimental to me because when I was hired in 1980, hindi ata 87, I think I was hired in 84. I was diagnosed to have a problematic heart. Meron na akong problema sa aking blood pressure. I was being asked to slow down, control my stress. And essentially, how do you do that when you are feeding your family, you're asking them to go to finish their medicine? Tapos nagsarado yung isang kumpanya namin sa Fioradan, then nagkakagulo na kay Ninoy. So Motorola was a big opportunity for me to find a job. A vice president ang level ko before I joined them. demoted ako, parang chief accountant lang. Pero yung sweldo, vice president. So okay lang ako. Binigyan pa ako ng allowance pambili ng kotse. And so I was, that's the best blessing I can always remember in my employment. Malaking sweldo, vice president. Ang trabaho, supervisor. And mayaman ang electronics dun eh. And therefore, ang lalaki din ang sweldo ng mga tao, pati rank and file. And so I did try to do my best, no? And napuna nung superior ko, isang American-Korean, may name of Prince, na minamani ko lang yung trabaho ko as general accounting manager. So pinatulong pa niya ako sa pag-automate. Tapos finally, nagkakaproblema sila sa budgeting, forecasting, financial reporting. He requested me if I can switch position to that incumbent financial planning manager who used to be my accountant in Delbros Transport. No? Nag-switch kami. And then nahihirapan siya. Sabi ko lang, on condition, you will give me a laptop. I was the first one to have an IBM PC among the staff sa Motorola. Hindi pa, kahit na electronic sila, hindi sila computerized sa administrative system. And so I had the chance to use my computer. I was the first one to really professionally use computers in my workplace. 2 years, it was easy work for me. And that was when I ventured, sabi ko, mag-aaral ako ng law. And that is where it took me 5 years, no? To 1987 to 1992. I went to law school while I was working with them. Binigyan pa ako ng scholarship dahil nagagamit ko naman yung law dun sa aking trabaho in taxation. So I was also a Motorola scholar in the College of Law. Bayad lahat yung tuition fee ko tsaka yung libro ko. And I passed the bar. Everybody there was expecting si Tito Joe will top the bar. Wala, hindi tayo nag-top. Okay. And so finally, I was moved to become finance manager. Until yun na nga, nagka-problema ang Motorola worldwide because of their Iridium project. Masyado napa-advance ang technology, napasubo yung investment, essentially na-bankrupt yung overall corporate na ibenta. Kaya yung original owner, sila Bob Galvin, finally lost their corporation. The Philippine operation was sold out. At ang bumili sa US, yung buong semiconductor business, yung mga senior executives din ng Motorola, kinuha nila yung retirement nila, and then they bought out the company. And the Philippines continued to operate as a semiconductor company. Pinalitan yung ginawa lang na on semiconductor. No? So yung ginawang on semiconductor. And they continued to operate a more advanced facility in Carmona, Cavite. Sinarado na itong sa kilometer 17 sa South Superhighway. Motorola gave me the biggest labor case that I handled for them. I did not want to fight my former employer, but I already told them that they really have to pay a vested pension fund that was there already 10 years before the retrenchment. And they, for any reason whatsoever, the local Filipino managers did not agree with me. And so they literally challenged me to say, sige, labanan mo kami. Kayang-kaya ka naman talunin nung Accra Law Office, sabi nila, o ikaw lang. I felt so bad about it, but since I was still part of management, I was asked to shut my mouth about the rights of the employees. But I didn't have to shut my mouth because they have a published policy manual defining that they will be entitled to a vested retirement pay in addition to the retrenchment pay. So while I was there, I did not try to use my legal knowledge against my own company. But after I left, the employees who were also now retrenched, came to me and say, Tito Joe, ilaban mo naman kami kasi what is right is right. It's a principle of Motorola. Tama naman talagang kunin namin yung aming third month pay in addition to the 2 months for every year of service. E di sabi ko, sige, sulatan natin ng demand letter yung kumpanya natin. Tingnan natin kung ano sasabihin nila. Let's not fight them. So we wrote them a letter. Ang sagot siguro mga 50 of the employees copied my draft demand letter. And they answered only 5. And they said, whatever you got, yan na yan. Gawin nyo na kung anong gusto nyo gawin. And because of the prescriptive period of 2 years on monetary claim, I was forced to file a case for unpaid retirement before the labor arbiter. There were about 1,200 retrenched employees. Originally, about 700 wanted to get me as their counsel, but ultimately only 400 signed in, and only 67 did agree to file the case. And yung iba, it was later pa. The long and the short of the story is we won that particular case before the Supreme Court. Napanalo namin yun. Kaya lang, mahabang storya, maraming maneuver, ayaw yatang gawing jurisprudence yun. Kung ano nangyari, naging ano na lang, parang obiter dictum or something. I still am not. Tapos, ginawang technicality yung mga naiwan, yung second wave. Kesyo yun daw pumirma ng complaint, di naman daw yung party doon. So, anyway, I'd like to just remember the beautiful people that I have had the chance to become friends with, because there are a number of them that I'd like to include here as a souvenir that nakadikit dito sa labor law ng 2022 bar examination, yung aking greeting sa kanila. Nasa huli naman So those of you who do not want to listen to this, you can now cut this particular portion and just keep your file, and you can keep on watching this without having to listen to this special Motorola dedication. But from the point of view of people who have been very close to me, I'd like to greet the following. Number one is the person who took me in Motorola. He is an American-Korean, magaling, CP, Certified Public Accountant. He headed our finance group. And he's now retired. I think he must be based now in Korea. And sana naman, he would be watching kasi he's no longer very young. But if he still can catch up with technology, I hope he reads this. Mr. Lin Che, I'd like to greet you. Merry Christmas. As I remember those days when we were together. I think we were together for 4 years before you were reassigned to Phoenix, Arizona. And I still met you when you finally landed as the Chief Finance Officer of Motorola Korea. And we continued our friendship, and I even asked you for some political help. Talaga yan. And continue to support me. Sir Rinche, I love you so much. I appreciate all the friendship and the help you've given me. You do not know that I was suffering from a heart problem, and the job you gave me was the salvation that I had when I was essentially a dying cardiovascular patient. The second one that I will never ever forget is an Indian Malaysian who became president and general manager of Motorola Philippines. And he was the one who brought to Fidel Ramos the idea of extending our tax holiday even if we were still here operating in Parañaque. And he gave commitment we will open up a new plant, a modern plant in Carmona, Cavite. He was the one who literally tried to work hard both on the Motorola senior management side in Chicago and Phoenix in order to get the funding and the tax holiday from President Fidel V. Ramos. Uh, Unfortunately, his perception is that the Filipino managers of Motorola tried to maneuver him out of the position until I finally was able to reach out to him on his winding up days here. And I said, Subra, I am not one of your enemies. I am your friend. And we had a lot of beautiful teamwork together. The preparation of the budget, I would give him buffers that would allow him to give a lot of fringe benefits to the employees. And he almost gave me the position of materials manager. But again, the politics of the local Filipino boys prevented me from moving out of finance, which is probably good in the long run. But Sobra finally was eased out. He was given a, what they call this, a dead-end position in Kuala Lumpur, Malaysia. And because of his frustration, he finally died. But the wife came back here when we dedicated the planting of one Nara tree beside our building in Carmona. And I really felt the friendship when she said, I'd like to go to see Joe Bisquera in his office before we go into our ceremony. And she did. And she said, my husband, Subra, continues to remember you as a friend at the time he was dying. Ang sarap naman ng pakiramdam. Kasi kung ang tingin niya, lahat ng mga Pilipino managers, tinitrador siya. Akala niya pati ako. But I was able to save the day. And say, no, yung friendship natin na nagsimula sa trabaho, hanggang ngayon, tuloy pa rin. And so he was one of the very few senior managers of Motorola that I have accepted as a personal friend. And Subra, I will always remember you as a friend and valued those times when we were together. He is a graduate of Asian Institute of Management, kaya kabisado niya lahat ang happy-happy dito sa Maynila. The third one that I really am so close on a personal basis is a person who could have been a lawyer. He is an engineer. He was working very hard to become a lawyer. His name is Noel Inocentes. Noel Inocentes is an outstanding engineer. In Motorola, he is recognized as the expert in centralized air conditioning as part of the facilities department. And when I was in second year, Noel started coming to my little cubicle to get inspiration, and he said he'd like to study law. And he did. Unfortunately, he was not able to justify the financial support of Motorola, but he continued. And he finished law at the JRU, Jose Rizal University College of Law. And he did not take the bar examination immediately. He reviewed 10 times. No, 10 years. Most of the time, he sits down in our review sa UM and listen to me. But Noel was not lucky to pass the bar on his attempt. And when he was preparing for his second attempt, he died a tragic death in the hands of his own first cousin in Mandaluyong. Nakakalungkot. But Noel is one fellow. Would have been a very good lawyer. My dear friend, sana naging abogado ka din. But thank you very much because after we left Motorola, you joined me as my legal assistant when I was appointed as Dean of the College of Law of the University of Perpetual, both in Las Piñas and in Biñan. So we were together, hindi lang sa Motorola, kung hindi, even sa legal profession. I'd like to greet, of course, my teammates in the Department of Finance. No? Siyempre, sila yung talagang tawag dito, naging kasama ko. And I'd like, nabanggit ko na si Rinche, But I'd like to mention the people who were working with me directly. Ito, inaanak ko pa sa kasal, si Aida Biesca. And kasama ni Noel, she helped me run the College of Law of the University of Perpetual. Aida, sana mapanood mo to. I will continue to be a real friend and also your former boss both at Motorola and also in Perpetual Health. Next, another very loyal and very efficient person whose cubicle was next to me in Motorola, si Medardo Ding Elejarde. He was the one doing all the detailed work in closing the books every month. And I probably do not know all his work, but he was the one who was doing the dirty work. Ding, I have not forgotten your loyalty and your good work. Another one who was working with me, and she already passed away, sayang, si Maryline Itaas. After she retired from Motorola, she retired in Cebu, taga Cebu City siya. There were 2 occasions when I had some speaking engagements in Cebu, and I had the chance to visit her and say hello to her. Medyo mataas lang yung blood pressure, malakas kumain, so she did not survive her stroke. Another one who's very near me is Mr. Pete Ramos. He is right now also my client. He was my payroll supervisor in Motorola, and I feel guilty. Hindi ko pa natatapos yung kaso niya. Dapat talaga ma-dismiss na yung nuisance criminal case that was filed against him. He lives a little nearby. The other one was my own classmate in college. He graduated BBA, CPA siya, cum laude, si Mr. Marcelino Tehelan, Kapampangan, who was head of our audit department in Motorola. I convinced Mr. Rinche to move him to audit because at one point he was my assistant manager for general accounting, but I felt that he deserved a little more recognition. So he was promoted and he retired during the retrenchment as the manager for audit or internal audit of Motorola Philippines. The next one is my inaanak sa kasal and who was also handling our accounts payable, si Evelyn Belen Biares Yona. And si Belen is married to a colonel in the military who was also a very good friend of mine. When I joined Motorola, the cost accounting manager was a young lady, single, by the name of Roxanne Borromeo. Roxanne was my student at De La Salle Graduate School who got a flat 4 under me. And I recruited to become my cost accountant in Permaline. And when I left Permaline for Smithline and French, and finally ended up with Motorola, I found out she was already the cost accounting manager of Motorola Philippines, and I came in on the same level as my former student. Roxanne is a very efficient person, very unassuming, tahimik. She may not know, but I was instrumental in pushing Rinche to recommend her to become purchasing manager of Motorola, mainly because I believe that she was honest, and I never heard her become dishonest when she was purchasing manager of Motorola. One who has passed away that I pity so much because he wanted to make good of himself was our own former financial planning manager who took over my position, also general accounting manager. His name is Fidelito Lito Trinidad. Lito is much younger. He used to work as an accountant in Delbos Transport Corporation. And when I moved over to Motorola, I was surprised. The most senior ones in the finance organization was Lito Trinidad, who used to be working with me in Delbos. And then my former student, si Roxy Borromeo, who was also head of cost accounting. They were the most senior. And so when I came in, para sumingit lang ako na senior din katulad nila. Some of my staff that have worked with me, Si Dada Velasco, apparently Dada and Belen visited Pete, and Dada was asking Pete, nasaan na ba si Joe ngayon? And she knew that I was still running strong. So Dada is not only very charming, but also very smart, no, in her work. Yung isa, galing sa operations ito, kinukuha ko, every namin tumulong sa akin, tinuturuan ko, very smart. Si Noemi. Uh, uh, Noemi, I am missing her surname na, but I am sure she's not Sancon. No? But she was very smart. No? Nag-aral ng accounting, natuto, maganda, masipag. The other one, very efficient, cashier namin for years. Si Josie Bermudez. And Josie will always, and I will always remember our continuing trust and confidence with each other. Nandun pa rin siya. And finally, the person who tried to understand my own idiosyncrasies and found it difficult. But I always valued her independence. Uh, my friend, Cora Ducusin. Cora, kaibigan pa rin tayo. Wala naman talaga tayong dapat na maging disagreement. No? Siguro, hindi lang parehong vibration, hindi lang parehong approach, but I continue to consider you a good friend. One of the areas that I came to be close to is yung Human Resource Department ng Motorola. Because I came in through them. I was recruited by them. But the one that really gave me so much good impression was the former head of the Human Resource Department, the Employee Relations Department, yun yung PR group na they appease any complaint by the employee. And he went up very high in the when he moved out of Motorola to join Jollibee. Si Robert Poblete. Robert, I continue to value the trust that you gave me. You were the one who supported me to spearhead the employees, Motorola Employees Cooperative. And you gave me the opportunity to realize also what I can do in the field of real bakbakang finance. And together with your support, we were able to make good on our employees cooperative. And the one who helped me there is a very dependable mistisahin na ang pangalan, si Gina Datu, who was our own, what do you call this, highest supervisor running the entire Motorola Employees Cooperative. Accounting major, very efficient, very strict, very loyal, you know. And she came from UE Accounting. So, hanggang ngayon, naalala pa rin niya ako, and I remember mahigpit ako sa kanya, but she never misinterpreted my strictness, not to be a friendly act. So Gina, I valued all the loyalty, efficiency, and friendship that we have shared together that allowed us to move the Motorola Employees Cooperative from about 17 million to about 30 million in total capitalization in a span of only 6 years. With your support, umandar ang ating Motorola, ako, Employees Cooperative. Hanggang ngayon, natuloy nyo at tinayo nyo. Another one in personnel that I have worked very efficiently and in a very beautiful, friendly manner is si Loida Martinez, who was handling the compensation and benefits. Siya yung talaga nagpapakilot. And we worked together. She trusted me so much even with confidential data that in return naman, I helped her. So it was a mutual scratching the back. Loy, I missed you. I have no contact with you except the last time. I think you were with one electronics company na naman, one of the Globe, Smart, the thing, no? And I'm sure you're making good. Oo. And then the one who recruited me in Motorola is somebody by the name of Remy Paralejas. Si Remy left Motorola to become one of the leading board members of the province of Rizal. Landslide siya. No? And Remy is a very aggressive person. maganda ang kanyang performance, so matalino. I just have not heard lately where she was. I hope her health has improved a lot and she continues to survive. And finally, yung isang fast rising na member ng Employee Relations Group, si Levi Diestro. O si Levi, matunog yan. He joined Ayala and parating naka-broadcast doon kay Joe Taruk at si Deo Makalma sa DCRH. Up to now, nababanggit pa siya. No? And he must have stayed with Ayala Corporation. And he's one of the young persons who made a good name for himself. Si Levy was the one who gave me the breaks of the game together with Robert Poblete to serve as the master of ceremonies of some of the big events, social events of Motorola in the five-star hotels, no? Where I was the master of ceremonies that was nourishing the ego of guys like Danny Javier, si Jim Paredes, si Buboy Garubillas ng Apo Hiking Society. Si Jose Marichan was so happy when I was handling his introduction. Sidekick pa lang niya sa performance noon si Regine Velasquez na wala pang pumapansin. So there were other performers, but these were the people that I remember as the entertainers, where Levi Diestro and Robert Poblete allowed me to become the focal point of the program, no? Akong master of ceremonies. Ang biro raw nila sikat noon na si Eddie Mercado. And so I was supposed to be the Eddie Mercado of Motorola. Happy naman ako kasi dati, ambisyon ko rin dati maging announcer. And in the operation side, ang dami po mga kaibigan ko, mga managers, but I can only catch up with some of them. Naging kliyente ko pa si Mario Cruz, who's very influential sa production line, front of line. Si Amy Franny, who continues to be in on Semicon, and she's making good. Kasama ko rin, tinulungan niya ako sa cooperative. Si Elmer Magtuto, who was our manager for the metal finishing group. Si Sam Clemente, who was in the Serdip group. And there are 3 people who belong to the rank and file, but they were significant. Ang tumulong sa akin on their battle for the benefit of the employees up to the Supreme Court is somebody by the name of Fede Vera. Si Fe, taga Binyan ito. Kilala yan dyan. And she was very influential in orchestrating all of our rank and file employees. Kilala siya. Sapang. And we were together. Without her legwork and her full support, we could not have won that case. 2 operators who continued to be my clients in the past and continues, si Josephine Lagunero also from Binyan, continues to be my client up to now. 12 years na yung labanan na lang family feud on their family home dito sa C5. And the other one is si Susan Tagam. Susan, naayos na namin yung kaso nyo, but you continue to be part of my memories as a good friend, somebody who looks up to me as a friend and as your lawyer. There are 2 other lawyers. There are 2 other senior managers from facilities that I will always remember as friends. Si Leo Villarosa and si Nestor Ladores. I hope you're feeling good. Mga kaibigan ko sa Motorola, mahal ko po kayo. Motorola was a company that saved me at the time I was suffering from the worst situation in my heart. Sa Motorola po, with a very respectable compensation, I was able to recover and naayos yung aking puso. Naging abogado pa ako under Motorola. At nagkaroon pa ng konting pera out of winning that particular case. I valued all the friendship that I had with Motorola. Sayang lang the company did not survive the way it was. So, So kayo po na mga taga Motorola, maaaring marami pang hindi ako nabanggit. Total apology to you. Most of you, hindi ko nakalimutan, maaaring wala lang akong masyadong maraming oras to list down because the limited time here on YouTube. But mahal ko po kayo. Sana po maalala nyo na once upon a time, we shared our lives together. We were there almost, in my case, 12, 14 hours. And it was even in Motorola, I started picking up my electric guitar and formed a band, no, na tumugtog dyan sa Carmona. No, nung inauguration ng Carmona, ang bisita natin doon si President Fidel Ramos at si Governor Johnny Remulla. Tugtog tayo ron. No, mga sound of the 60s and our American guests were enjoying it. That was my first time to perform in a public display of my own capacity as a guitar player, electric guitar. So with this, I love you so much. Merry Christmas po. And sana you will always remember that we were very good friends. And we will always be friends for the rest of our lives. Goodbye po as I wind up this particular slide. Thank you.